Hello and welcome to the Harlan Institute Ashbrook Virtual Supreme Court competition. This is the round of 8, really 12, and this is the first match that we'll be recording. Today we have two teams from the Baldwin School, Win Conger and Lighthouse Wu, and from Lake Oswego High School in Oregon, we have Luisa Valentine, Emily Zhao, and I'm honored to have two guest judges today, Mithan Masakhani, as well as David Gans will be judging. Without further ado, petitioners begin whenever you're ready. You have 10 minutes.
Thank you, Your Honor. Mr. Chief Justice, and may it please the court. My name is Lighthouse Wu, and I, along with my co-counsel Win Conger, will be representing students for fair admissions, the petitioner in today's case. We would like to reserve 5 minutes for rebuttal.
You may.
Would the court like a brief summary of the facts?
Brief, please.
Thank you. In 2014, petitioner Students for Fair Admissions filed a suit against the University of North Carolina over the affirmative actions policies employed in its admissions process, alleging that the inclusion of race in the admissions process is inherently divisive and discriminatory on the basis of race, and therefore contradicts the guarantee of equal protection and equal treatment in the 14th Amendment. After several years of litigation, the district court ruled in UNC's favor, and following appeal, the case Students for Fair Admissions versus UNC then advanced to the U.S. Supreme Court for the Fourth Circuit, and then the Supreme Court proceeded to grant certiorari.
This court should revoke its decision in Brother v. Bollinger as a violation of both the 14th Amendment's Equal Protection Clause and the 1964 Civil Rights Act for 3 reasons. First, Brother's decision is inherently inconsistent with this court's long-standing equal protection jurisprudence. The original intent of the 14th Amendment was to enact temporary provisional policies for freed African Americans until their citizenship was officially secured. The Civil Rights Act from 1964 further forbade discrimination on the basis of race in federal institutions. In Brown v. Board of Education, the court advocates above all for racial equality and against the unequal denial of specific benefits for the student applicants. The original text, history, and tradition thus all affirm the importance of race neutrality in education, but Grutter fundamentally deviates from the court's equal protection jurisprudence.
Okay,
Secondly,
if I could, sorry, you only get through one. Let me ask you a question, right? You're asking us to overrule Grutter and potentially Bakke as well. Just last term, this court overruled Planned Parenthood versus Casey. We overruled Roe v. Wade. We overruled the Lemon Test in the context of religion. We overruled precedents on labor relations, right? It seems that every year this court seems to overrule more and more precedents. At some point, doesn't this affect the legitimacy of the court, that this new court with a different majority is overruling precedents that they just don't like? Doesn't this weaken the court as an institution? How do we address that here?
Your Honor, we first want to emphasize that the principle of stare decisis is not sacrosanct. Furthermore,
I get stare decisis, but legitimacy, right? That's sort of baked in. How will the public perceive us as if we're telling them, no, you can't, you've done this for half a century, you can't do this anymore? How does that affect how people view the court? Forget stare decisis.
Your Honor, the court should act as an institution to protect people's constitutional rights. So as long as the court is making decisions based on a rational basis and a righteous interpretation of our amendment, the court
is it enough for a case to be wrong? I mean, don't we need something more before we overturn half a century of precedent?
no, Your Honor. In fact, the Grutter being overruled would be in line with the Brown v. Board decision and this court's longstanding jurisprudence of equal protection. The use of race in the admissions process.
Let me just stop you. Are you saying that Grutter violates Brown? Is that what I just heard you say? We
do believe that Grutter is a violation of this jurisprudence that the court has shown in Brown and
the segregation. I'm sorry, the segregationists in Topeka, Kansas are the same thing as the DEI bureaucrats in Chapel Hill. Is that the argument?
No, Your Honor, we're saying that in Brown, the court recognized the importance of race neutrality. However, Grutter deviates from that principle.
How do you deal with the fact that contemporaneous with the 14th Amendment, the Reconstruction Congress passed many measures that took account of race to foster equality, and did so over the objections of members of Congress who said they had to be colorblind. It seems like your argument is based on the argument of those who opposed the 14th Amendment and other Reconstruction legislation.
No, Your Honor, we are saying that although during the time of the 80s, 60s, and 70s, there is Reconstruction policies such as the Freedmen's Bureau. However, even the framers of the Freedmen's Bureau Act did express that those measurements should be temporary and should be provisional. They should be acting as remedial actions that provide resources, services, and land to free the African Americans. Those are temporary policy and should be struck down as soon as you achieve this purpose. So we are not saying that those policies should last forever. And yes, we are saying that the Constitution should be colorblind.
But don't you have to take account that there was the same debate we're having today, they had right at the time of the 14th Amendment's passage, and that debate ended with a recognition that taking account of race to foster equality was permissible. How can we just ignore that?
Your Honor, in consideration of these institutions is enacted surrounding the legislation 1860s and 1870s, we cannot consider them analogous to modern day affirmative action policies, despite what the respondents claim. The Freedmen's Bureau Acts and the surrounding legislation were principally remedial, whereas modern day race conscious policies differentiate between applicants and discriminate under the mere interest of diversity, which is no longer sufficiently compelling, even as an interest under the strict scrutiny.
Well,
We cannot broadly identify.
Yeah, I guess my question is, this case went through an entire trial, and the district court found facts. So I guess my question is, what's your best evidence that Asian American students in this case are being harmed? And what do we do with the fact that UNC put forward a lot of evidence about all of the benefits of their affirmative action program? So even assuming, right, that we're in this land where there is equal protection concern, if there are sufficiently good benefits, why should we say it's unconstitutional?
Your Honor, the Asian American applicants during the UNC application process are severely disadvantaged because they along with white applicants, they have to score higher in the test, and as African American applicants have an unfair advantage during their process. Now, UNC engages.
Does the evidence actually show that? I think my colleagues asking, what evidence can you point to that actually demonstrates that? I mean, it's just anecdotal. I mean, what can you point to that proves that point, please?
Moved to analyses completed by Students for Fair Admissions that showed that in the process, Asian American applicants are severely disadvantaged to the extent that an African American applicant in the fourth highest decile has a higher chance of admission than an Asian American applicant in the top decile.
But can you show that race is a dispositive factor, right? I mean, there are 40 something factors they list, right? Can you show that race, let me say it differently. Did the trial court find that race was a dispositive factor? Let me put the question like that, please.
Your Honor, although race acts as one out of many factors during student application process, the SFFA analyzes that it is in fact a determining factor in 1.2% of all the UNC in-state applications. In that case, it will be approximately 700 students in each annual cycle being denied of their application based on their race. So in our case, this is a violation of many people's 14th Amendment rights.
Mhm.
And I guess to ask the other end of my question, which is UNC put on a lot of evidence about all the benefits to the campus and to the academics of the university. of their affirmative action program. What's your best response to all that evidence?
Your Honor, we believe.
Are you saying? I guess are you arguing there are no benefits to the affirmative action program to the university?
Your Honor, we believe that affirmative action is not justified because it aims to achieve a student body diversity. However, it is not UNC nor the court's place to define what diversity is, because in this case, in UNC's case, the African American applicants are being provided with an advantage. However, if that's the definition of diversity, it should not be that case.
Okay, thank you, Counselor. Your time has expired. 15 minutes, please, for respondents, please. Whenever you're ready, you can begin.
May it please the court, my name is Emily Zoe.
My name is Louisa Valentine, and together we are representing the respondent, the University of North Carolina, in the case of students for fair admissions, the University of Carolina. Justices, would you like us to provide you with a brief explanation of the
Brief,
facts?
please. Thank you.
Yes, Your Honor. In November of 2014, the petitioner, Students for Fair Admissions, sued the University of North Carolina on the basis that their race-conscious admissions process violated the Equal Protection Clause of the United States Constitution's 14th Amendment. Their claim is that race-conscious affirmative action, which is practiced by numerous college admissions offices, including the University of North Carolina, discriminates against Asian American and Caucasian applicants on the basis of their race. The defendant, the University of North Carolina, claims that their admissions process is holistic and abides by the precedent set forth by Greta v. Bollinger, and additionally utilizes racial diversity on college campuses as a compelling state interest, and that their admissions process is narrowly tailored as required under the strict scrutiny standard.
The question presented is race-conscious affirmative action consistent with the 14th Amendment to the United States Constitution?
Because race-conscious affirmative action has a narrowly tailored compelling state interest, is honoring of stare decisis in the constitutional history of allowing race-conscious legislation, race-conscious affirmative action is consistent with the 14th Amendment of the Constitution.
Today, my co-counsel will be discussing the original telos of the 14th Amendment and its permittance and encouragement of race-conscious affirmative legislation. Followingly, I will be discussing how race-conscious affirmative action is consistent with the rulings of Brown v. Board of Education of Topeka by diversifying college campuses, how race-conscious affirmative action does meet the standard of strict scrutiny set by the 14th Amendment, and lastly, my co-counsel will explain how the University of North Carolina's policy is consistent with the principles of stare decisis in precedent cases.
So firstly, the University of North Carolina's policy on race-conscious affirmative action is consistent with the original telos or intentions of the Equal Protection Clause of the 14th Amendment of the United States Constitution. This is because the Equal Protection Clause guarantees not only equal treatment like the petitioners argue, but also equal opportunity. And as was pointed out during my petitioner's argument.
Counselor, if I could interrupt you, I read the text, right? It says equal protection of the laws. Where do you get equal opportunities? I don't see that in the text.
So under the original telos of the 14th Amendment of the Equal Protection Clause, the vision was sort of to ameliorate these negative lasting impacts from the institution of slavery. If they were only to guarantee equal protection, then what we would see is
what evidence, I mean, you can think telos, it's a nice word. Maybe original intent is the word we use more often. What evidence you cite to support that intention or telos?
The passing of legislation in the 1960s and 1970s, like the freedom
even 18, right? 1860s?
18, yes.
Right, no, I know what you meant. So let's talk about that legislation. I think your friends on the other side say that legislation is remedial in nature, that it was meant to remedy the new civil war that just happened. It was only a couple of years away in the past. Whereas here, UNC, are you making an argument based on remediation here?
No.
No, Your Honor. We are making the argument, one, that racial diversity is now a compelling state interest.
Okay, good. Okay, let's go back then. So if let's assume that the sort of race-conscious legislation was permissible to remedy past segregation, discrimination, and so on, does that necessarily get you to equal opportunity for people who are not descendants of slaves, right? People today who have no connection to slavery at all.
I'm sorry, could you rephrase your question? Your
There are
Honor?
lots of people who get racial preferences who have no connection to slavery, right? Of all races, right? If the 14th Amendment's framers enacted these laws to remedy the atrocity of slavery, how do you then extend that to people who did not suffer from slavery?
Well, race-conscious affirmative action nowadays has nothing to do with the original need for reparations. And in fact, we must focus on the compelling state interest of a racially
Oh,
diverse.
no, I get that, but for example, the city of Richmond v. Croson, are you familiar with that case?
No, Your Honor.
Okay, Adirond versus Pena?
No.
Okay, well, these are cases in which the court said that you can use racial preferences if it's directly to remedy segregation or discrimination, right? But here, you're not claiming that. So my question is, aren't all these precedents about diversity and the like, isn't that deviating from what was the telos or the intention, which was to remedy the atrocities of segregation, the Civil War?
The vision of the framers in passing the 14th Amendment is to create a more racially diverse country and a more racially equal.
What evidence do you have to support that? I mean, I get the Freedmen's Bureau Act, but that's not really about diversity. It's about people who had nothing, who were destitute, were given, some property, some benefits, some government services, help them get on their feet. Right. I don't see how you can go from the framers' intentions or understandings to wanting a more diverse society. That sounds like a very modernistic argument.
I agree. I would say that the need and the compelling state interest of a diverse campus would be a developmentalist argument, whereas reparations has to do more with originalism.
However, we would also argue, sorry.
Well, I would
No,
say that,
Sorry.
did you-
Justice.
Go ahead, finish your sentence.
I would say that the Constitution is very aware of race. For instance, the 15th Amendment explicitly talks about how color and race should not be used in discrimination in voting. And
I guess the question is, why is diversity such a compelling state interest? I mean, is there any evidence to show that our society would be unable to function if UNC was slightly less diverse? Why is that such a compelling state interest?
Well, the utilization of affirmative action as an equalizer amongst races and a tool to advance civil rights for people of color has been consistent throughout history. In the peak of civil rights movement in 1961, John F. Kennedy signed the Executive Order 10925, referencing affirmative action as a way to create equal opportunity and treatment for Americans of color, specifically within government.
Okay, let me ask it on the other side of the strict scrutiny analysis, which is, do you need affirmative action in order to achieve diversity? So the North Carolina and the state of Oklahoma both have roughly the same percentage population of Hispanics in their state. The University of Oklahoma and the University of North Carolina also have roughly the same percentage of Hispanics in their university systems. But the University of Oklahoma does not engage in affirmative action because it's prohibited from doing so by the Oklahoma Constitution. So why is it necessary for UNC to do it in order to achieve diversity, whereas Oklahoma doesn't do it and achieves the same level of diversity? How does that meet the narrow tailoring part of strict scrutiny?
Well, hypotheticals are not needed to conclude that race-conscious affirmative action prevents segregation and bolsters racial diversity, even though it might be true in that specific case. The laboratories of democracy of America have witnessed what happens when affirmative action is eliminated. In 1996, the state of California approved Proposition 209, which prohibited the considerations of race, sex, and ethnicity in the admission process of public education. Alongside with California, the states of Texas, Louisiana, and Mississippi also upheld bans on race-conscious affirmative action after the 1996 Hopwood v. Texas decision. Prop 209 had an immediate impact in the state's elite universities in California. Black and Hispanics enrollment at Berkeley and Los Angeles flagship campuses.
Oh, okay, but the diversity decreased at the University of California, Berkeley. But I guess my assumption is that your argument is not that we want diversity for diversity's sake. is that we want diversity to improve the academics of the university, to improve student learning, et cetera. But I look at the University of California at Berkeley, and it looks like a great university. It looks like a stellar university with a top law school and a top undergraduate. So why is it a compelling interest, even if you assume those drops in diversity, when the University of California at Berkeley looks just fine? Looks like a university any of us would want to send our kids to.
Because America is a melting pot of cultures and races. And if we want to prepare the scholars of today for the world of tomorrow and modern America, you must prepare them.
Is there any evidence that the University of California at Berkeley is churning out unprepared students?
There's no evidence that they're churning out unprepared students. However, just simply because the University of California is a great university doesn't mean that they couldn't be better if they were to utilize race-conscious affirmative action in their decision-making process.
If I can pivot a bit, what's the exact level of diversity that you're looking for?
Well, we understand the standard of a substantial mass that is critical mass that is needed in order for students of ethnic minorities to not feel isolated.
All minorities?
Yes, all
Yes.
minorities.
What about Asian Americans? Are they included in there?
Yes,
Yes.
Asian Americans are included, and in the University of North Carolina's affirmative action policy, as well as policies across
But
America.
your
there
friend
is
on the other
no-
side, maybe not conclusive evidence, but put forward some evidence showing that Asian American students are treated worse off, that they need to have higher test scores to get in at the same deciles. How do you deal with that? I mean, it seems that some minority groups treated better than other minority groups.
I wouldn't say, well, first, Your Honor, I don't think that there is actually any conclusive evidence that Asian Americans are discriminated against under race-conscious affirmative action policies, and that race is simply just a factor of a factor of a factor in the University of North Carolina's
But
policy.
is it a negative factor or a positive factor for Asian Americans?
It's
In fact, it is shown that when race-conscious affirmative action is put into universities, female Asian Americans are the second group to benefit the most from it. So, and
Did the trial court make any findings about discrimination against Asian Americans?
I believe that the trial court found that Asian Americans are not in fact discriminated against at a substantial enough level or at any level.
And what was that based on?
Briefly, your program explicitly gives benefits to only URMs, underrepresented minorities, and Asian Americans aren't included as URMs. Isn't that correct?
I believe so, yes, Your Honor.
So by benefiting non-Asian American, non-white students, how is it possible that Asian Americans do not have any negative effects from your affirmative action program? Your
Honor, the way that the affirmative action process and the admissions process at the University of North Carolina works is that it is a holistic process which is inclusive of all sorts of factors, not just race or academics or anything like that, but it utilizes all different factors from all different aspects of an applicant's life, meaning that when underrepresented minorities are given sort of more of a consideration because of their race, Asian American applicants and Caucasian applicants who are not considered underrepresented minorities don't need to rely on race as either a negative or a positive factor. In fact, the university is allowed to consider all sorts of various other factors to help them make their decision.
And are there alternatives other than use of race that University of North Carolina could use to achieve the diversity that you seek?
No, Your Honor. The University of North Carolina is continuously remedying and assessing their admissions policy, and they have found that the only way in order to achieve this compelling state interest of racial diversity is through the current process that they use.
Did the university try race-neutral alternatives?
The university, I believe, has been assessing and has been evaluating the usage of race-neutral admissions processes.
Let me sort of change gears here. This case, I think, has been very controversial because at least among many Asian American students, there is a bias. Right? Let's assume that you're right, that the numbers don't show it, but there's substantial evidence that students across the country de-Asianify their resumes and that they try to hide their identity. Are they just all wrong? And even if they're not entirely right, shouldn't the court be attentive to how UNC is at least creating the image that some minorities are just not as wanted as other minorities?
I think that, sorry, no, Your Honor, I don't believe that it is the University of North Carolina's job to change how students apply to their university. The University of North Carolina is only one university out of the millions, thousands of universities across the United States. And when we're looking at this idea of Asian Americans de-Asianifying their resumes or applications, I believe it is actually the court's job to uphold this decision as a way to further prove that Asian Americans and other races are not actually discriminated against in affirmative action, but rather it is to the benefit of all students.
We pray that this court.
Thank you. You can finish.
We pray that this court will uphold the lower court's decision in upholding students for fair admissions, the University of North Carolina. Thank you.
Thank you, Counselor. All right, petitioner, 5 minutes rebuttal, please, whenever you're ready.
Thank you, Your Honor. Your Honor, contrary to what the respondents state, the affirmative action policies are not consistent with the 14th Amendment, which is inherently race neutral. It is furthermore not consistent under the institution of strict scrutiny. As in this current era of educational diversity, the discriminatory use of race can no longer be sustained as a compelling interest in the admissions process. Race cannot be considered a compelling interest in parental custody under Paul Moore v. Sidoti, and societal discrimination at large cannot justify race-conscious affirmative actions under Wyatt v. Jackson Board of Education. Parents involved further established that unless schools taught the benefits of broader student body diversity, it was patently unconstitutional and can furthermore, under Adiron, not be employed directly in K-12 public education or in the workforce.
Broader states that.
Well, let me interrupt you for a moment if I can. Let's just talk about reality here, right? So for half a century, college has been allowed to use affirmative action, right? And then suddenly they can't. What should this court say to underprivileged minority students who will not be able to gain admission to UNC because of this court decision, right? How do we handle an entire generation of students who cannot have the same rights that their parents and grandparents shared?
Your Honor, there are certain, there are a lot of alternative admission options that UNC can use to still provide an equal opportunity in education to all of its applicants. For example, geographic recruitment from a socioeconomically diverse, like a variety of areas, or admission policy based on zip codes, or admission plans for top candidates of underrepresented institutions. All those alternatives.
But isn't it true that you presented evidence of all of these possibilities in court, and the trial court found that based on the evidence, none of those achieve diversity as well as UNC's program, that there will be some drop in enrollment in African-American students?
Your Honor, we acknowledge that. However, diversity should not be the goal for admission process, as it's not a compelling state interest to achieve diversity. As we argued, diversity is ill-defined, and university, it's very hard for university to find what racial groups are underrepresented, what racial groups are privileged and not. In the end, in your proposing scenario, if the UNC were to use race neutral alternatives and it ends up with a less diverse student body, it certainly would be a regrettable and unfortunate outcome, but this is an outcome we must accept.
Mm-hmm.
Do you think that the university can use facially race neutral measures that are adopted for a race conscious purpose of increasing the admission of Black students? Or is that unconstitutional as well?
Is Your Honor, as we stated, the usage of race remains inherently discriminatory under this Constitution and this court's precedent. And the court has an obligation to strike down discriminatory laws accordingly.
Right, but so but I want to know is, could they use a facially neutral measure that was adopted to increase the number of Black students admitted to the university?
Let me give a variant just to answer this question. What if we had a question? Check this box for the descendant of a slave. Descendant from a slave, check this box. Would that be okay?
Your Honor, no. Oh, it would not be okay because we object to the formulaic addition of a plus strictly on account of the race of the applicant.
But if
And in this-
remediation was a permissible purpose from the 1860s, couldn't we still say if you're the descendant of a slave, you're still suffering for it, and we can give you a plus factor, a plus point?
Your Honor, although at most we believe it would be permissible for race to provide a contextual background, perhaps in the common application, and to provide context to an applicant's character or experience within the narrow tailoring of strict scrutiny. The formulaic response of a mere plus, where race defines the decision and disregarding any background information of context, would be impermissible under this court's precedent.
In summary, no student should gain an advantage because of their race, even if race only acts as one of many factors, even if race is only a checkbox. And in your case, even if race is only presented as a checkbox that's named the extendants of slavery.
Okay, very good. Thank you so much. All right, the case is submitted. Congratulations to both teams. That was a very, very good exchange. I think you've seen the level of intensity and how it changed from the first round to the second round. And it's a lot harder to get your points across when we're interrupting you nonstop mid-sentence many times. And I try to be a little bit of a jerk, and I'm sorry, I try not to be a jerk, but I go out of my way to be jerky during these rounds, so you feel what it's like, because you might be in front of a judge one day, maybe Nathan and David can speak to this, where you're not gonna get your intro in, right? The Supreme Court now will actually let you speak for about a minute or two when you start. Didn't used to be like that. It used to be free for all. Mr. Chief Justice, please the court, and Scalia would run you over, right? That was the chronology back in the day. So you did well. Also, you were poised. What I like about both teams is you didn't sort of panic or you didn't get very nervous when I threw bombs at you. You sort of just handle it. It's like, okay, Blackman's throwing a bomb at me. Let me just deal with it as it comes. You tried to stick to your positions. You didn't deviate. You didn't try to backtrack. You sort of had your game plan and you stuck to it. Also, one unique part of this competition, at least for Mithun and David's benefit, is that there's two of you up there. And the sort of the back and forth, I thought was pretty smooth, pretty seamless. It wasn't like one talking over the other or interrupting or cross-talking over each other. It was pretty smooth, and that comes with practice, right? I'm sure you guys practiced that, had to sort of do the handoff with alternating questions. And I noticed it. I see what's going on. And also, you look like you're having fun. Maybe I'm wrong. Maybe you're miserable, right? Maybe you're just awful and you feel like terrible, but it looks like you were enjoying yourselves. And this is something that if you can find joy in what you do, you have the best job in the world. I love what I do. Myth, I'm sure Dave will say the same thing. When you can find satisfaction in what you do, you're set. So I hope you're all now sophomores, juniors, seniors in high school in 5 or 6 or 7 years. I'll see you in law school maybe. And maybe we can judge you for a championship round for moot court. So congratulations to you both. And if Mythin or Dave or anyone else has any comments, I hope you can give some insights to our kids.
I'll defer to David since technically he's judge too. So
Yeah, I mean, I think you did really great dialogue, and we didn't go easy. We asked a lot of very tough questions and pushed back kind of on what you were saying. And, you did a really good job at sort of sticking to your guns and not kind of, so that's, for being in high school, it's incredibly impressive. So, I would say kind of congrats on that. You're starting early, which is always a wonderful thing.
Thank you so much.
Thank you.
And Mythin?
yeah, echoing both what was said, very impressive. As I said to respondents team before petitioners team got on, y'all are probably, better than most lawyers I see in court. And these are very, very tough issues. These are issues that thought about, very smart lawyers have thought about a lot. And the sad part about it for you is that like your 3 judges have probably thought about it more so, these issues more so than 99% of lawyers in the country. And so you got some really, really tough questions. And I thought you handled them very, very well. And the amount of knowledge that you're able to cram in, not being law students, not being lawyers is very, very impressive.
Very good.
So much.
Maybe one question from each side if you have it, otherwise I have to run to class as well. I don't mean to rush you, but maybe we'll have you take a quick question from you. And then Luisa, you're on mute.
Oh, sorry, we were just talking to each other.
We were.
That's it. I saw the lips moving, nothing came out. Anything you'd like to ask us?
Mr. Blackman, you asked in another round, you asked that a question about more, okay, I think this is how you worded. You asked that because when the doctor is treating a patient, if the doctor has the same race as the patient,
Yes.
the patient would have a higher chance of curing. And you asked, well, if you don't admit Black Americans into university, wouldn't that make Black patients dying? So what would be your answer to that?
Yeah, I did ask you that question, didn't I? Well, I think there's 2 answers. First off, if you read the amicus brief, I think you can challenge the facts. I think the level of health difference between a Black and white doctor is almost so small as to be almost unimportant. But let's assume the facts are correct. I think you basically have to bite the bullet and say, Your Honor, in any society, when you have to have equal treatment of the law, there will be inequalities, and that's not something the Constitution countenances. There's not a good answer to it. And like this way, if the justice is asking that question, he or she's probably not voting for you. So you can, it's terrible advice, but the Supreme Court, you can afford to lose a vote every now and then. You're not going to get everyone's vote, and especially in a case like this, not going to happen. All right, I need to call this to a close. I'm sorry, I have class. I have to go in like 3 minutes, but as soon as you can please sign off, and I can talk to the judges for a bit. And I will have the results posted by either Friday today or tomorrow. So thank you all so much.
Thank you so
Thank
much.
you so much, Your Honor.
Thank you.
Take care, everyone.